week number 7, and tonight we're continuing our discussion about topic 5, the registration system for security interests in personal property security under the PPSA and the PPSR. So it doesn't sound all that interesting, but in practice, this is a very critical area for you to consider, because we're dealing with disputes and the potential for avoiding disputes by looking at this process. Continuing our discussion about the PPSA 2009 Commonwealth, we're now looking at enforcement. And when we talk about enforcement, we really need to think about a few different concepts. One is, how do we go about creating something which is enforceable? Then, what are the enforcement procedures? And how does all of this work when multiple people lay claim to having an interest in property? So priorities comes into it. Now, whilst the Act is very helpful in many ways, unfortunately, it's not particularly helpful in that the terms enforceable and enforcement procedures are not defined in the Act. But if we look carefully enough, we can find some specific provisions that assist us in understanding about enforcement security interests, which is a closely allied topic. And so how can enforceable security interests be the subject of enforcement procedures? A good starting point is section 12. And I say that because if we're looking at enforcement and we're looking at enforcement procedures, we need to consider security interests. So as we did last week, if you're watching this as a recorded session, please call up the Act now, the PPSA 2009 Commonwealth, follow along. And for those joining us for the live session, perhaps you'd be kind enough to do so as well. So if we look at section 12, it provides us with the meaning of security interest. So it means an interest in personal property provided for by a transaction. In order to understand that, we need to understand what we mean by an interest. And generally, interests can be legal and they can be equitable, or they can be both. We need to understand what we mean by personal property. So there's that threshold question for in the entire unit, what's real property and what's personal property, and then what's provided for in a transaction. So if we're better understanding this, we need to branch out as we did last week. So a security interest secures payment or performance of an obligation. We talked about that last week as well. And then helpfully, section 12 subsection 2 provides some examples. And it talks about an interest in personal property provided for by a number of different type of transactions, including charges. And what do we mean by a charge? Has anyone come across that term? Has anyone come across the term mortgage, hire purchase agreement, consignment, lease? In equity, it's been discussed. Good. All right, so when we talk about a charge, we're really talking about something which attaches to property, creating an interest. Now, I know that's a circular type definition, but if I was creating my flowchart, my guide to answering a problem around this, I would definitely look at what we mean by a charge and have some way of referring to some of the basics like charge, mortgage, hire purchase, consignment, lease of goods, and maybe transfer of title. So subsection 3 then talks about a security interest, also including a number of different types of interests, such as accounts or chattel paper, commercial consignment. So anyone have an idea of maybe an example of a commercial consignment? Does anything come to mind? How about motor vehicles, motor vehicle dealers, floor stock? It might be owned by the dealer or it might be provided by the manufacturer on some form of commercial consignment. Account debtors are included as well. Now, subsection 5 includes, has a statement. A security interest does not include a licence or an interest prescribed by regulations. Now, this is the sort of area where examiners try to find something which fits within the exclusion as a form of trick. That's not necessarily an exam hint, but you get the idea that it's important to look at and understand the exclusions just as much as it is to understand what is included in the obligations. Now, there are some general rules that apply to security interests in relation to personal property. To better understand that, we need to consider Section 16 of the Act, which provides a guide to Chapter 2. Chapter 2 relates to those general rules relating to security interests. So again, thinking backwards, if we have a problem that relates to something that involves the enforcement of a security, we'll want to know what a security interest is. We look at Section 12, we get an idea of what's a security interest, and then we need to consider the general rules relating to that security interest in personal property. So Chapter 2 provides the answers, and Part 2.1 simply includes Section 16, which is the guide. Part 2.2, if you're looking at the Act, provides some general principles relating to security interests, and it covers you can see there, it talks about the agreements that governs them and their enforceability. And here's an important concept that you need to work in to your logical outline, that is perfection. So the part 2, 2.2, refers to how security interests are attached to personal property and are then perfected. Part 2.3 deals with the concepts of possession and control of personal property. 2.4, some rules about attachment and perfection of security interests in certain situations. So even though we're talking about the general rules, there are specific situations which might take you outside the general rules. 2.5 sets out the circumstances in which a person takes an interest in personal property free from a security interest in the property. Now, this is a very important part, because if you're involved in, let's say, advising someone who's acquiring some personal property, then a fundamental thing that is expected of you is to ensure that that personal property is free from a security interest. Because if it's not, what can happen in relation to that personal property that has been acquired by your client? Next week, next month, next year? What's the dreaded call you don't want to receive? Any thoughts?
Someone else has an interest.
Yes. And worse still, thanks Amy and Shona.
Threatened repossession?
Yes, that's right, or an actual repossession.
Yeah.
Worse still, someone is driving out of my driveway with my yacht that cost me $150,000. What do? Do I stop them? Do I call the police? You get the idea. So it is important that we have a good idea of how to understand the process of acquiring a property free from a security interest in that property. So look at part 2.5 for the general rules. 2.6 sets out how to work out the priority between competing security interests or some other types of interests in personal property. Again, this is the sort of area that examiners will look at because, you know, you might be asked to advise different people in different circumstances. And on the face of it, a number of people might seem to have a good claim to property. We have to work that out. And the dispute between people who have what appears to be a claim to a property interest is where we determine the priority between them. Now, very importantly is this. There are general rules that apply here, but I've mentioned within the PPSA there are specific security interests where the rules that deal with priorities might change. So have a look at the default rules in section 55, which is part of 2.6, and that'll give you some idea of at least the starting point. And part 2.7 deals with transferring and assigning interests in collaterals. Now, just to digress for a moment, you're probably wondering, why am I walking you through this legislation so carefully? There's a number of reasons. The first is that when we consider answering a legal problem or determining the legal situation, it's always preferable that we go to the primary sources of law. Here we have a key primary source of the law, which in many ways, if you understand it, will avoid the necessity of reading the secondary sources of law. I shouldn't say that because editors of textbooks wouldn't particularly like me saying that, I shouldn't think. But for example, I mean, those of you who've acquired this guide might find it extremely useful. But by the same token, if you read the Act carefully, you understand the flow of it, you work out for yourself what are the key areas, how do I find the appropriate definitions, the general rules and the exceptions, and then you read this, you'd probably say, this is good, but it's really restating in some ways, this is not a criticism, it's really restating in some ways that which is in the Act. But I like the way that I've set it out because it's more logical to me, and I've been through that thought process. So what I'm saying is there's a danger in going straight to the secondary sources when you should really attempt to concentrate on the primary sources of the law and work through it yourself, referring to the secondary sources for confirmation that what you've understood seems to be the case, or for clarification in circumstances where you find there's some uncertainty or ambiguity in the way you're reading the material. I hope that makes sense. Now, going back to this important chapter 2, section 17 provides a guide to the part and sets out some of the general principles. So the principles relate to enforceability, and they're effective only if the security interest is only effective if it has attached to a collateral. So if we look at section 17 in that regard, you'll see some reference to the this term collateral, which is a new one coming in. So what does it mean? As a security interest attaches to collateral when the grantor, the person giving, has rights in the collateral or can transfer it to a secured party for value. And a security interest is only enforceable against a third party if it has attached to collateral and the secured party possesses the collateral, has perfected the security interest by controlling the collateral, or has entered into a written security agreement that describes it. When you look at acts, you'll see that many of them have hyperlinks. And of course, I'm sure you've worked out by now that if you hit that hyperlink, it will take you to a definition for the term. So sometimes it's hard work reading an Act because you find yourself bouncing around. This is where you need to create that little bit of structure for yourself to give you a guide as to how it means. You'll see that the part also provides specific rules about how the security interest is perfected. We've come across that term, and how it is continuously perfected. And perfection occurs when a security interest has attached to collateral. So we've now got two terms that refer to attachment to collateral. A security interest being only effective if it's attached to collateral, and perfection occurring when a security interest has attached to collateral. And any further steps needed to make the security interest effective against third parties have been taken. So again, you can hit the link taken, which will give you an idea of what it means to take that step. Now, Section 19 enforcement is important, again, because if you're acting for the holder of the security interest, you want to do something about it if the person to whom the security interest was provided defaults. So a security interest in Section 19 is enforceable against a grantor only in respect of particular collateral, only if the security interest has attached to the collateral. Again, we see another reference to security interest attaching to collateral. So, a type of essay question, this isn't necessarily an exam hint, but a type of essay question that an examiner might ask you on this topic is, explain the significance and circumstances by which a security interest has attached to collateral. What does that mean? And how does it affect enforceability? Or something along those lines. Now, unless you've been through this process in reverse, it's going to be hard to answer that type of question from simply looking at the Act afresh, in broad terms rather. So a security interest attaches to collateral when the grantor has rights in the collateral or the power to transfer rights in the collateral to a third party, and so on. So read that section and take particular note of the concepts of attachment and collateral. You really need to understand what we mean by that. And there are, as I mentioned, the exceptions, things like crops, etc. Now, we've talked about this term perfection. What's the rule that relates to that? Have a look at Section 21, because Section 21 provides for the main rule in relation to perfection. So a security interest in a particular collateral is perfected in certain circumstances. A or B, and in B, there are three conditions. I won't read it, but I'm just highlighting for you that during the week, if you haven't already done so, I want you to read these sections and work through them in a logical manner for yourself. Then we move to priorities, and in that regard, have a look at Part 2.6 of the Act, which provides the commentary in relation to priorities between security interests. I've already identified Section 55 as important because Section 55 provides for the default priority rules. Section 56 is important because we've already identified that having an interest that is continuously perfected is significant, and Section 56 tells us how that is to be continuously perfected. So there are some basic rules that you'll see by reference to Part 2.6 of the Act. So what are the basic rules? Number one, perfected interests take priority over unperfected interests. Number two, priority between perfected interests depends on the order of perfection. And number 3, priority between unperfected interests depends on the order of attachment. And section 55 talks about the default priority rules. Again, I won't go through that with you now, but I do urge you to look at that section carefully and work through. I think this really lends itself well to flowcharts, dot points, hyperlinks. You've already got that in the Act. There's nothing wrong with cutting certain parts of the Act with the hyperlinks included, dropping it into your document, into the one that makes sense for you, so that you've got a quick link to different words, phrases, concepts, etc. So section 55. Now we're getting close to the end of this commentary, but I do want to move way to the back of the piece of legislation to highlight something called constructive knowledge, because it does crop up from time to time. It's section 297 of the PPSA. So go to section 297, which is under the general terms of miscellaneous, and you'll see that it provides the meaning of constructive knowledge. So when we talk about constructive, we're meaning it's almost like a deeming provision, as if. So you may have actual knowledge, or you may have constructive knowledge, which means you may not have actual knowledge, but the law deems you to have this knowledge. We see it, for example, in the case of drugs. People might have actual possession of dangerous drugs and therefore be guilty of possession of that item, or they may be guilty of possession through constructive possession. For example, if drugs are in a location which is where the person lives, they're deemed to have knowledge of the existence of the drugs there in certain circumstances, which we call constructive knowledge. So you'll see this term constructive quite often in law, sometimes in terms of dismissal. In employment law, we might talk about an actual dismissal, or we might talk about a constructive dismissal, a deemed dismissal, something where the law says, in a sense, it's as good as. I hope that makes sense. So have a look at section 297, which provides for the meaning of constructive knowledge. Now, another important thing that I haven't talked about so far with I haven't really emphasised, but I'll just mention it now, is purchase money security interests. I mentioned it at the start of last week. So the PMSI regime is important. This is a special priority rule. It's available to a secured party who lends money, enabling the buyer to obtain the collateralised item, defined as the purchase money security interest, the PMSI. Now, have a look at the important section is section 62, which deals with when purchase money security interests take priority over other security interests. So again, it's this priority issue. And the special PMSI rule arises when a secured party specifically provides value for the purpose of acquiring collateral. Now, none of this will make much sense unless you put in the hard yards. Sorry to have to do that to you. It's just, you've got to do the work here to understand the terminology, make sense of it, understand the general rules, have some idea of the exceptions, and at all stages, when you're putting this together in a logical manner for you, make sure that you have some way of linking to the authority for the proposition or the statement. You'll need that for referencing purposes, and you'll need that to cross-reference as well. In terms of enforcement of security interests, have a look at Chapter 4. Start with Section 107, which provides a guide to the chapter. So this chapter, enforcement, sets out how to enforce a security interest in personal property. Now, here's an important thing to remember. By contract, parties can contract out of some of the provisions of the chapter. Again, the sort of thing that examiners just love to pick on, little exceptions or maybe minor exceptions or major exceptions. Security interest in liquid assets can be enforced by giving a notice to the person who owes an amount of money to the grantor. So you'll need to understand what we mean by liquid assets. Other kind of assets can be seized and disposed of in accordance with Part 4.3. So your client who says, someone is towing out my luxury yacht, you need to understand the enforcement procedures, and you need to understand the procedures regarding seizure, and then ultimately the disposal or retention of collateral. So proceeds arising from the disposal of collateral must be distributed in accordance with Section 4.4 of the legislation. Then Section 108 provides a guide to the part, which sets out the rights and the remedies available to a party to a security agreement for enforcing a security interest. Those words, rights and remedies, are significant, and it's something that I use quite often. I quite often incorporate into exam questions this concept of remedies, because, and it's a unit that I'd love to take in this university one day, but remedies is a really fundamental thing, because it answers the question, what can we do about this? What is your remedy? And when we talk about a remedy, it raises a number of issues. It raises, what is your legal right? What is the interest that you claim to have? Is your remedy something that gains priority over others? Because you'll need to do that to establish you've got this remedy. Is your remedy legal, or is it equitable? Are we looking, is your remedy, you're seeking a declaration or an injunction or some other equitable type remedy, or are you seeking damages? So that's a remedy at common law or equity. And what court are you seeking this remedy? So what's the jurisdiction of the court or the tribunal that you purport to take this argument? So if you're seeking a remedy, in that one word, it raises a whole lot of questions. So for your toolkit, I would recommend that you have a section on remedies that you might build upon, and in that you might provide some guide to yourself, something that's logical to you about what are the different questions that might be raised when we think about remedies, and how do we get an idea of which court or tribunal we should initiate our application or claim for a remedy. Again, by reverse engineering this, when you're reading a case, do it actively and take note of the court that's dealing with the matter. So are you dealing with the Supreme Court, the District Court, the Magistrates Court? Are you dealing with the tribunal? And then wonder and ask yourself, well, why is it there? Why is this matter in the District Court as opposed to the Magistrates Court or the Supreme Court? Is it just a matter of the monetary value? Because often it isn't. Oftentimes it's not just the monetary value, but it may be that a particular remedy that's being sought is through some form of legislation available only in selected courts or tribunals. I mean, for example, if you had a dispute over a retail shop lease, then the appropriate jurisdiction is the Queensland Civil and Administrative Tribunal, even if the dispute in question is worth $700,000. It's still a matter for that tribunal. If it goes over $750,000, then it's in the Supreme Court. But you wouldn't go to the district court for that type of dispute. Does that make sense? So you've got to think about the remedy in the context of a whole range of things. So have a look at section 108 and then look at section 110 because it provides specifically for issues around rights and remedies. So we've covered a lot of content in this Act. It's clearly an important piece of legislation. Note some of the exceptions. For example, have a look at sections 8 and 10. And you'll see section 8 talks about interests to which the Act does not apply. So a highlight there would be land and fixtures. And an important case, and I think it's in the study guide, is it's a New South Wales Court of Appeal decision from 2017. It's a power rental OpCo Australia, power rental against Forge Group Power Proprietary Limited, and the citation 2017 NSWCA Court of Appeal New South Wales 8. And so the court considered the meaning of fixtures within the context of the PPSA 2009. We've talked about fixtures within the context of the general law, degree of annexation, purpose of annexation, things like that. But within the context of this legislation, you'd want to have a look at the legislation and look at this Act, this decision as well. But in dismissing the appeal, the Court of Appeal confirmed that the meaning of fixtures under the PPSA is determined by applying the common law approach. Well, that's a bit of a relief, isn't it? Because now that we've learned the common law approach, it'd be nice if we could use it within the context of PPSA. So this case highlights the possible application of the PPSA to different type of agreements, such as leases and hire and bailment agreements, even where there are arrangements for structures or items which may be anchored, affixed or annexed to land. And again, an area for examiners, an item that might be standalone as personal property and have available to different people interests within that property, does that change if suddenly that piece of personal property is now anchored to something else, or it's affixed to something else, or it's annexed to land? So that case deals with a few concepts that would be very useful to consider. So the court had to consider whether a lease was a PPS lease within the meaning of section 13. So have a look at section 13, which talks about a PPS lease of the PPSA. And to do that, the court had to consider whether, in this case, turbines were fixtures within the meaning of the PPSA, because the PPSA does not apply to an interest in land. We mentioned that earlier. Have a look at section 8. So there are some things that fall outside the scope of the PPSA, and one of those are excluded interests in an interest in fixtures. So the court determined in that case that the definition of fixtures in section 10 of the PPSA is to be interpreted in accordance with the common law meaning of the term. Have a look at paragraph 96. And accordingly, they came to the factual conclusion that the turbines were not fixtures within the meaning of the common law meaning of the term. Have a look at paragraph 156. And just bear in mind a basic distinction in the dictionary, section 10, because the PPSA divides personal property into either consumer property or commercial property. The other thing that you might want to do is have a look at the Australian Financial Security Authority website, because the AFSA administers the PPSR. And if you look at the website, you'll see that it describes it in this way. It says the PPSR is a national online register that can provide information to help protect consumers when they're buying personal property, such as cars, boats, or artwork, but not including land or buildings. And if you check the PPSR before you buy, you can find out if the personal property you're buying has security interest attached to it. This is important because if you buy the personal property subject to a security interest, it is possible that someone with a security interest will repossess it, as we discussed at the outset tonight. Oh, you've been very patient. Thank you. That's 2 weeks in a row that I've just talked at you. I hope that I have at least, this is overstating it. I hope that I've inspired you, encouraged you is a better term, to undertake some active, proactive reading for yourself so that you can really work through these issues and understand them. Just a quick story. Years and years ago, I think the Retail Shop Leases Act came in 1994. When it came in, I struggled to work out, because this was a brand new regime, and I'm used to the common law approach and the Property Law Act approach to leases. And now they've brought in this retail shop lease regime, which is very significant. And many, probably most commercial leases in Queensland are retail shop leases. So you have different types of commercial leases. Those that are retail shop leases and those that are not retail shop leases. Most of them are probably retail shop leases. So we've got a brand new act that deals with that. And I had to work out, well, when is a lease, a commercial lease, a retail shop lease, and when isn't it? So I went through exactly what I'm asking you to do for the Retail Shop Lease Act, working it out for myself in a way that made sense to me, and I've had that ever since. So that's sort of ingrained and it's documented. Now, if you look at the Act, other people would come up with a different way of describing it or thinking it through. But you really need to do that for the PPSR. Okay, thank you. Any questions? Comments? Are we up to the challenge? I've asked that of this unit before, and you've always said, yes, you're up to the challenge. So again, you're up to the challenge. You're trying to work through the PP. No, says Carolyn, I'm not doing it. Nice response. I know you're only joking.
I've approached my way of working
Tammy.
with the flow chart by actually pulling apart section 3. So I've started there and then basically assigning the different sections of the Act to section 3 and then starting to pull it apart that way.
I think that's an excellent approach. And section 3, I think, is critical. Understand that, break it down like Tammy has done, and you're well on your way. So that's a very good approach. Any other questions, comments? All good? All right. One of the side issues as a result of looking at that piece of legislation as carefully as we have is that it brings into play issues around statutory interpretation. So I mentioned the importance of that. In some ways, we know there's a rider with this. We know that the Acts Interpretation Act has important but limited effect to this piece of legislation, section 11, in case you couldn't remember it. So when it comes to statutory interpretation, just remember the different approaches, but if you're going to provide any commentary about the the statutory interpretation, make sure you refer to the Acts Interpretation Act. If you're looking at Commonwealth legislation as we are now, make sure that you refer to the Commonwealth version of the Acts Interpretation Act. Rookie error if you don't. Think about the different approaches We all remember the literal approach, the contextual approach, the purpose of approach. Go with the purpose of approach. That's what is important now. Don't talk about the old types, the mischief rule and things of that nature. Remember, there are some common law presumptions as well. One of them is words have their current meaning. That is, unless the legislation says otherwise, this legislation says otherwise. Words have their technical meaning, and things not included are excluded, is another common law presumption that you might want to keep up your sleeve, because it might be handy if you're trying to work out the answer to a legal problem based on interpreting this legislation. Remember, of course, if you're referring to legislation, you want to think about the general principles. So Section 15AA of the Acts Interpretation Act of Commonwealth is really important. It's one that you probably want to toss into answering a question that's based around statutory interpretation of a Commonwealth piece of legislation. It's very general in terms it says, in interpreting the provisions of an Act, the interpretation that best achieves the purpose or the object underlying the Act is preferred to any other interpretation. So if you're on the borderline, you don't know what the answer is, when you look at the Act and you're trying to interpret it, via Section 15AA, call up the purpose or the object of the Act. It's only useful if you can identify and cite what is the purpose or the object. If you're looking for some cases, Mills and Meeking, 1990 169 CLR 214 is important, it's useful, and it simply indicated that the purpose of approach has supplanted the literal approach and should be used even if there is no uncertainty or ambiguity. So if you want some authority as to why you adopted the purposive approach, Mills and Meeking is good in conjunction with Section 15AA. Then you always Project Blue Sky somewhere or another. In determining the object or the purpose of the legislation, have a look at Section 15AB of the Commonwealth Acts Interpretation Act, which provides the authority for looking at intrinsic and extrinsic materials. And if your question relates to an interpretation of a contract between parties, and we've talked about contracts and whether something is excluded by the contract or not, then you may have to add into your question something about contractual interpretation. So the traditional approach is objective approach. The subjective intention of parties is not taken into consideration. So generally, when interpreting the object of a contract, if we're looking to interpret the contract, the court will look at each of the terms of the contract from the perspective of a reasonable person. What would a reasonable person think this term means, rather than necessarily what the parties actually thought, through their evidence. There are different rules that relate to collateral contracts and things of that nature, but that's more for a contract unit rather than a property law unit. And another thing that you might want to consider is this: when you're considering the interpretation of a contract, courts will look at uncertainty within the terms of that contract and will on occasion try to fill the gaps in that, but there are limits. So the court will imply a term, deem a term into a contract if it's reasonable and it's fair, if it's necessary, but all around the basic test of, well, it goes without saying. It's that obvious, and that it can be clearly expressed and it is consistent with the express terms within the contract. And again, courts do that by using an objective test. So they're just a few brief comments about how you might want to consider both statutory interpretation and, to a much lesser degree, contractual interpretation when answering a problem around this type of issue. Make sense? All good? Build that into your flowchart somewhere and use it in other units that you're dealing with. Anything where there's a statutory base, just cut and just move that across, or a contract base, move it across as well. So it's worth putting a little bit of time in to get those things right. And I've mentioned the jurisdictional issue. So if, for example, you're a judge making a decision on an issue of priority, in the back of your mind, the first thing that the judge has to be satisfied about is, do I have the lawful authority to make a decision here? You don't want to make a decision and then find that on appeal, the appeal court says, even though the parties brought this matter to you, judge, you didn't have any legal authority because you don't have the authority by statute to make this sort of order. You understand what I mean? The Mental Health Review Tribunal has no jurisdiction to make an order in relation to the enforceability of a personal property security interest dispute between people. Now that's pretty obvious, but it's an underlying theme that you need to be considering whenever you're answering a question. All good? All right, we've got just a little more time, which means that I'll make a start now on topic 6. So topic 6 relates to fragmentation of property interests in land. What does that mean? What are some of the key issues? So fragmentation, what does fragmentation mean? Can anyone describe it? Explain that word, fragmentation? Any thoughts?
I guess, John, if we think of property as a bundle of rights, we might think of the sticks within the bundle as different fragments. Very
good. So again, we're talking about, I like the fact that you've said bundle, because that implies there's more than one. And if we have more than one, then presumably we can break them down, can't we? And so that is the process of fragmentation, the breaking down of these different interests, these different rights that we have. Now, there's a few key issues relating to this. One of them is the doctrine of estates. And so you'll need to have, as part of your toolkit, some reference to the doctrine of estates. What does that mean? And you'll need to think about the doctrine of tenure, T-E-N-U-R-E, because the doctrine of estates is linked to the doctrine of tenure. Have I said to you in the past that I've taken conveyancing and I actually much prefer teaching that, because I'm talking about real things. I'm not talking about this sort of theoretical concepts. And if I mentioned that my least favourite piece of legislation ever is the Property Law Act, because we're talking about fundamentals of property law, and I should be, the PPSA is a really good piece of legislation because it sets it out there. We've got a Property Law Act. You'd think if I'm talking property fundamentals, I'd be referring you to step by step through the Property Law Act, and I'm not, because it doesn't work for me. Now, other people might say Property Law Act is great and it really explains it well. So sorry to be in some ways raising these issues and saying, I need you to understand that these are concepts that you'll come across, and I need you to have some quick way of identifying what they mean and how they link together. So doctrine of estates is linked to doctrine of tenure. And equity and equitable interests are important in relation to property, especially land, and also trusts are relevant. So those of you doing equity, I'm sure you're coming across trusts with Alex, and they're relevant to property law as well. So if you look at the study guide and what it is that you should achieve in topic 6, we need to have you identify the legal features of the doctrine of tenure and maybe some historical development. Appreciate the significance of radical title to land. Identify legal characteristics of the doctrine of estates. Appreciate the requirements of determinable and conditional interests, which limit property law interests and rights. Appreciate how the equitable concept of a trust emerged, statute of uses and all of those things, and future interests and the role of common law in equity in preventing the free alienation of land. What do we mean by alienation? Can anyone give me a word that relates to alienation of land?
You're able to assign it or sell it to another party.
Exactly. And it would be lovely to think that we could move away from a lot of these terms and phrases and concepts that initiated in England, I don't know, 300 years ago. And we've just perpetuated them as if it's really important that we keep them. Sorry, I'm on my soapbox now, but it frustrates me. This should be such an interesting area of practice at a fundamental level, but we just get bogged down by these terms. I guess the problem is that every lecturer that comes along and talks about them continues to talk about them, but it won't break until legislation changes it. All right. So yes, Ivan.
May I just ask a question? It'll probably come up later in the weeks ahead, but to give me a heads up, is there a rule of thumb that would assist me distinguishing between legal and equitable rights in land?
Yes, that's a really good question. In general terms, there are 2 ways, I think, to distinguish them. Number 1 is in terms of the type of remedy that's available, and number 2 relates to the process of registration. So think of it this way, dealing with the second one first, registration. If you have an interest in property which comprises of, let's say, a registrable transfer in your favour that you've achieved, then you have an equitable interest in that property. That equitable interest can become a legal interest once registration of the transfer has been effected through the Registrar of Titles. So once your name is on the title deed, in the Torrens title, then you have a legal interest in the property. But where you have something short of that, you have an equitable interest, and the equitable interest is, I have an interest in the property which is capable of enforcement. I have the opportunity to go to a court to seek an order that I seek, damages, injunctions, declarations, etc. So that's one way of describing it. The second way of describing the distinction between equitable and legal is to think about the remedies that are available. And if we think about legal remedies, the first thing that comes to my mind is common law damages. Equitable is much broader and provides opportunities for courts to order injunctions, make declarations, order specific performance, order equitable compensation, deal with quantum merowitz and those sorts of remedies. So your interest may be categorised as legal or equitable depending on the type of remedy that you have. as well as the issue around registration. I know it's a very long answer, Ivan, but does that make sense? Is that what you're sort of getting towards?
Yes. So if I put a $20,000 deposit on a property down the road today, this is hypothetical, between today and when I settle, I have an equitable interest in that property. And my remedy, if the vendor fails to perform, then I would have an equitable remedy in suing for breach of contract. Is that correct?
Yes, you would. So I agree with you. Short of having the registration affected through the Registrar of Titles, your interest would be equitable. And whilst you could still claim, and this is where it gets a bit confusing, you could still claim common law damages. The important thing there would be that you would have the entitlement to seek an equitable order, for example, specific performance.
All right. To complete the contract and settle.
Yes, and the order that you'd seek of the court is effectively forcing the seller to proceed, and in default of the seller signing the document, then having an order that the Registrar of Titles may sign on behalf of the seller. So it's got some teeth. And that way you can affect the registration of the transfer, and then you've got the legal title to go with that equitable interest.
So once the property is registered in my name, then I acquire the legal title. Is that right? Okay.
That's it. Yep. That's my basic way of thinking about it and describing it. So thank you. That's a good question. Excellent. All right. So some of you have, I think, evidence now. So you do. So we'll wrap it up. Thank you very much for your attention. I'll make a note of where we're at. So please, now this week, I do want you to read the PPSRA, Personal Property Security Act very carefully, understand the PPSR, and then move into this area of fragmentation of property interests and start to, or continue to develop your own systems and flowcharts. All good? So thank you very much for your attention tonight. We'll see you next week. Bye then.
Thank you.